We are often asked how to get legal guardianship of a parent, and in order to get guardianship, a court proceeding is required. So, the first step in Rhode Island is that we have something called a decision making assessment tool completed by a treating physician, and that document is going to go through the needs of your parents. So, do they need help with decision making related to finances, healthcare, relationships, residence? And so, we could have a partial guardianship or a full guardianship depending on the level of need, but that is the first step, the first document we need in order to file it with the court and establish a guardianship. Now, when we petition a court for guardianship, your adult parent who you're trying to obtain guardianship over is going to have someone called a guardian ad litem who's appointed to meet with them. So that's generally an independent third-party attorney. The court chooses that person, and they're going to meet with your parent to make sure they truly need the guardianship, and then also meet with you to make sure you are truly a suitable guardian. If it's determined that your parent needs the guardianship, you are a suitable guardian, then we have a court hearing in order to get a certificate of appointment to allow you to manage your parents' affairs. Along with a guardianship, we are required to report health status changes as well as all finances to the court on at least an annual basis. So once you've obtained guardianship, you have to let the court know what your parents have coming and going from a financial standpoint and file an annual report with the court to indicate what has happened with their affairs as well as any changes in their status. It's important to know that guardianship is a more restrictive option than powers of attorney. And so often we start with a discussion of, does the person have capacity right now? Guardianship is truly meant for people who do not have capacity right now to make their own decisions, such that they're not able to execute a power of attorney or a legal document that would say who they want to manage things for them if they're not able to. If there's still some capacity, then we may want to look at powers of attorney first because it's less restrictive. We don't have court proceedings and court oversight for an ongoing period of time. Now, capacity from a legal standpoint doesn't necessarily mean you don't have a cognitive diagnosis. So that's something that comes up a lot. We have many clients who have a diagnosis of Alzheimer's or dementia, for instance, who do still understand the objects of their bounty, which is the legal standard. What does that mean? It means who do you love? Where are your accounts? Where are you? What do you own? So it's really, can you tell me specific things about what your stuff is and who your people are, such that you're able to really clearly understand the powers that you're giving away through a power of attorney. And if that capacity standard is met from a legal standpoint, even if we have a cognitive diagnosis of Alzheimer's, dementia, something like that, we often can still have powers of attorney executed, which is a way that then we maybe don't need guardianship now and hopefully never, because those powers of attorney can control instead.